Arrested for DUI in Indiana? Here's what to expect next. Now, every case is different, but I'm going to give you a general overview of what you can expect from the time of your arrest through the conclusion of your court case if you were arrested for a DUI, or more commonly known as OVWI in Indiana. So you went out with some friends, you had some drinks, and on the way home, maybe you swerve a little bit in your lane, run a stop sign, whatever reason, you turn without using your turn signal, and the police pull you over. During that interaction, the police may notice an odor of alcoholic beverage, may have slurred speech, bloodshot, glossy eyes, what have you. Eventually, the officers might have you come outside, do some field sobriety tests, and then based on that, if they believe that you're intoxicated, they could ask for you to take a blood test or a breath draw down at the police station or the hospital. So that's how you get to the arrest stage. You're pulled over for whatever reason, officer notices signs of intoxication, and then they take you for a blood draw or a breath draw. That is the arrest part. Now, typically when people are arrested, they will go to jail and usually be booked in and booked out, maybe spending anywhere from 12 to 24 hours in custody before being released. Now, typically for a first time DUI in Indiana, you're going to be released on your own recognizance, meaning once you're booked into the jail, the judge will issue an order releasing you to the public pending that first court date. So the first thing you're going to get when you're released from jail is your next court date. It's going to have a date and time of when you need to be in court next. And that date could change based on when the state files the case. So when the police officer makes an arrest, they send the probable cause affidavit to the state, who has the final charging decision. Now, some courts will go based on probable cause. So they'll look at the police report, say, we think this person was intoxicated, and then they'll file the case. That usually happens the day of or the next day, which means that first court date, you could be, in fact, the first time you're in court. However, some counties and some courts wait until they get the toxicology results back. Now, that can take anywhere from weeks to months. And what that means for you is the state may decline to file the case until they have the toxicology reports back. So you may have that first court date when you're released from jail, but then you show up that day and turns out, hey, the state hasn't filed the case, you can go home. And what that typically means for you is you're in a waiting period. Now, that can be weeks or months, but eventually, if the state does get toxicology results back and decides to file the case, at that point, the state will either ask for a warrant or a summons to get you back into court for your first court date, which is your initial hearing. The initial hearing for a DUI case is a very important court date because there comes a lot of deadlines that need to be met in order to keep you in the best possible going forward in the case and in your life. The number one thing at an initial hearing is the state is going to ask that your driver's license be suspended. If you go in there without an attorney, you're not going to know what to say to keep your driver's license intact. However, if you get an attorney involved before your initial hearing, your attorney can file petitions and ask the court to not suspend your license while we get things rolling behind the scenes to get specialized driving privileges petitions filed with the court. So that way, while the case is pending, you're still able to drive to and from work, to and from doctor's appointments, picking up children, all of your basic life necessities. Now, if you're deemed what's called a refusal, what that means is during the officer's interactions with you, when they asked you to submit to a blood draw, that you said no, you refused that blood draw, and a warrant had to be obtained to get those results. If you are a refusal in Indiana, that's an automatic 1-year driver's license suspension that will go into effect at your initial hearing. However, there are ways, again, that an attorney can keep you driving while the case is pending, even if you were deemed a refusal. But that's why it's super important to get an attorney hired before your initial hearing, so that way your attorney can keep you driving throughout the case and it's not a bigger hindrance on your life than it already has been. After your initial hearing, for the next 30 to 60 days is going to be the discovery process. So that's the time where the state's going to be turning over evidence that they have over to you or your defense attorney. So that's going to be things like police reports, body cam, dash cam, toxicology reports if they have it. But it's also a time for us to provide evidence to the state as well. If we have a good defense on our side, maybe there was some medication that was in your system, but you were prescribed it, we can turn that over to them. But we can also take depositions of the police officers, the chemist, the nurse, basically all the state's witnesses involved. And the depositions where they come into my office, they're placed under oath, and then they give a statement, but we're able to ask more questions than what's in that original police report to kind of flush out more things that happen in your particular case. Now, eventually, once discovery is done, the state typically is going to send over what their initial plea offer is. As attorneys, we have to go over any sort of plea offer with our client, but ultimately it's up to you to decide what's in your best interest, and no one other than yourself can make that determination for you. So eventually, once we get to a certain point, the judge is going to want to know whether or not this needs to be set for trial or whether or not this needs to be set for a plea agreement. Again, your attorney can walk you through the pros and cons of each side and each decision, but ultimately it has to be your decision and your decision alone. If you're facing a DUI in the state of Indiana, we at the Marc Lopez Law Firm, I know we can help you. Please give us a call, 317-632-3642, and always remember, plead fifth.